1212 PL 129. And who's here?
Your Honor, I'm Terry Connor, and I'm here on behalf of Mr. Whiteman, as well as the various entities also intervened.
Okay, Ms. Tauber.
Your Honor, Rick Tauber of Tauber Law Office is here on behalf of Dr. David Ashton.
Okay, Mr. Yanni.
Yes, FBA, MMBS Inc., and also Northwest Indiana.
Okay.
Also, Eric Liffendahl on behalf of Jack Whiteman individually and Whiteman and Associates.
Okay.
And Eileen Pruitt on behalf of the Pathology Specialists.
All right. And we're here for status. Is that correct? Yes. And did you get a copy of this? I think I just got a motion to set a new trial date. Any objections to setting a trial date?
Yes,
There's objections? Okay. Well, where are we at with the case, I guess?
We have a stay, Your Honor, but I think Ms. Connor may wish to speak to why we think that should continue.
Your Honor, I'm also involved in the criminal case against Mr. Whiteman. And as the court's aware, there was an indictment issued on about September 17th that was unsealed a couple of weeks later. However, the trial date is set for April 13th of 2015. We would strenuously object at this point to the court lifting the stay of the civil proceedings. At the time that we were last before the court, the concern of the plaintiffs was whether or not any charges would actually be brought, and therefore there would actually come to fruition a conflict between Mr. Whiteman and the other parties' rights to elicit information from Mr. Whiteman to prepare for the civil case, and Mr. Whiteman's right to remain silent under the Fifth Amendment. Well, clearly at this point there's really no issue. Because of the issuance of the indictment, Mr. Whiteman does have a very strong Fifth Amendment interest in remaining silent in terms of both trial and the civil case as well as further discovery. Not only does that impact Mr. Whiteman's ability to present the issues from the defense and cross plaintiff's point of view, but it also impedes the ability of virtually every other defendant in the case, including the corporate defendants, from presenting a defense to the allegations brought by nephrology. The plaintiff would argue that because, in fact, nephrology is not named in the indictment, that, in fact, there is no interrelationship between the indictment and the civil case. Your Honor, I will assure you that having done significant investigation into the government's case and the government's actual steps toward investigation, that virtually every witness in this case, including matters directly addressed in the indictment, do in fact interrelate very heavily with this case and allegations of the plaintiff. In fact, discovery revealed by the government indicates that what I would suggest is probably the primary factual witness in the criminal case actually was questioned at length regarding nephrology, and for accounting purposes was heavily involved in transactions involving nephrology. In addition, Your Honor, the affidavit in support of the search warrant, which we discussed at length with the court, has not yet been revealed by the defendant to the defense, Your Honor. However, we have no doubt that that affidavit will reveal once again that the foundation of the investigation in this case relates directly back to the civil matter. We would therefore ask the court to continue to stay in the state of discovery until after the criminal proceedings have been resolved, and I would suggest a date somewhere around May 1st. If something were to happen before that time, and we would have a more clear indication of when the criminal case, for example, if it was to be resolved by some sort of plea, certainly we could make this court aware and the parties aware, and we could go forward on it. I would also add, and I do think that it's important, that on September 18th, when Mr. Whiteman appeared before Judge Cherry, Assistant United States Attorney Thomas Radcliffe, who was handling the bond matter for the government, specifically indicated that the government anticipated additional charges coming. I think it's quite obvious from what we know about their ongoing investigation that once again that would be directly related to nephrology. Also, I would add that, as indicated in the indictment, which the court has a copy of with the plaintiff's motion, that Dr. B is in fact Dr. Ashback. So the interrelationship between these two matters just cannot be avoided, Your Honor, and would ask the court to continue this case.
Okay. Anything else?
Your Honor, very briefly, we believe, Your Honor, that if you lifted the stay, it would be very prejudicial to Dr. Ashback, one of the co-defendants in this case, in that there's allegations by the plaintiff that there was a conspiracy between Dr. Ashback and Jack Whiteman, that Dr. Ashback breached his fiduciary duty with regard to his office and responsibility as president of the corporation, all of which is interrelated with the management of the checkbooks by Jack Whiteman's office. Without the testimony of Jack Whiteman, Your Honor, in this case, it's very prejudicial to Dr. Ashback, because we're certainly not going to be able to try to gather information about what was done and how it was done with regard to the checkbook. And so, it is prejudicial to have, for the case to proceed and for Jack Whiteman to take the Fifth Amendment without us getting any testimony really hampers on and basically eliminates our ability to defend Dr. Ashback in this case. And for that reason alone, Your Honor, we would respectfully request that the stay be extended until after the criminal proceedings are concluded. Thank you.
Who's Dr. B?
Dr. Ashback.
I thought he was Dr. A.
No, he's Dr. B.
Who's Dr. A?
That's the government, Your Honor.
All right, go ahead.
I had a somewhat similar request to the court to be made on behalf of primarily Northwest Indiana Medical Properties Partnership, which is a group composed of 5 partners that own the properties together. And certainly the inability of those, Jack Whiteman is one of those partners, but the inability of the other partners to elicit testimony to protect the partnership would be very prejudicial to those remaining partners. And so for that reason, we would urge the continuance of the stay. Also make it on behalf of MMDS Inc. It is true that Jack Whiteman is the current sole shareholder of MMDS Inc., but it's a corporation that employs many, many people. Many people's livelihood is dependent upon that corporation, and it definitely is foreseeable in one form or another that either that corporation, those shares could be taken over by another party, not in this courtroom or represented by anyone in this courtroom, that those shares could be somehow at some point handled or addressed by the government, or other third parties that may directly impact the ability of many people to continue their livelihood. And I think at last I heard that probably could be upwards of 70 people. So I do feel obliged to make that this request on behalf of MMDS Inc. as well, because there is a very strong and compelling reason to do so.
Okay.
Judge, I'll just join Connor's motion on behalf of Mr. Whiteman.
All right, sure.
On behalf of the nephrology specialists, we would note that we were here several months ago to discuss the stay, and based on the representations that there was substantial overlap between the indictment and this case. And at that point, we had to take their word for it because the indictment hadn't been unsealed. We now know, based on the indictment that was issued and unsealed, that the counts are totally unrelated to this case. They are 4 counts of bank fraud that involve other parties, not nephrology specialists. To the extent there are more allegations or counts coming, we can't speak to that, but at this point there is no overlap between the cases. And to stay this case indefinitely, when it's been pending for nearly 4 years already, is very prejudicial to nephrology.
So you're saying none of these allegations have to do with nephrology?
They don't, Your Honor.
Scheme to commit bank fraud doesn't have anything to do?
No, those are unrelated. Dr. B and Dr. Ashcroft, we don't know who Dr. A is, but we know it's not nephrology.
What about that? These aren't related, or they are?
Your Honor, the specific allegations that give rise to the 1344 conspiracy allegations do directly involve bank accounts that were held by Dr. Ashbeck. What is important, Your Honor, well, I think we have to clarify also, when we were here last time, there was no indictment. It wasn't that we didn't have we had a sealed indictment. At that point, we had a search, which clearly implicated nephrology. What we have now is we have a first wave of indictment, as the government has said on the record. They anticipate additional charges. We believe that those charges will very directly be involving nephrology. But, Your Honor, the government's investigation, which we did not know clearly at the last hearing, absolutely involves nephrology. Because every single witness that has been interviewed about nephrology. And in fact, the witness who is the primary witness, it appears, fact witness in this case, also handled the accounts for nephrology. And the statement that was provided to the government on the nephrology, by that witness, clearly encompasses transactions involving nephrology. I would say the reason that the government gave for a very quick but limiting indictment was that the charges that they believe that they would like to hold Mr. Weichman responsible for coming out of Dr. A, who's not nephrology, Dr. B is Dr. Ashbeck. They were very, very tight with the statute of limitations. I believe they're talking about within a week the statute of limitations was going to expire on those charges. And therefore the government indicated that it had to bring the indictment. It did immediately or lose the allegation. But again, on the record before Magistrate Cherry, Tom Ratcliffe, who is an assistant of the United States Attorney's Office, represented that more charges were coming based on the information we have. I think there's little doubt.
Well, even, let me ask a question, even if, let's say, for argument's sake, that these aren't have anything to do with nephrology, how would Mr. Weichman testify? He still couldn't testify, could he?
He can't, Your Honor. He will take the Fifth Amendment.
He could, but he's not.
Sure. But
And practically speaking, we can't compel him to.
And Your Honor, further, practically speaking, plaintiff has been seeking discovery as it relates to Dr. Ashbeck's bank accounts, any involvement between Jack and those bank accounts. That's what they feel is relevant to their case. They're asking for discovery on it, and those are exactly the allegations in the indictment, how Mr. Weichman dealt with Dr. B, Ashbeck's bank account. So they're clearly interrelated, otherwise they would have asked for discovery on it, and he cannot, as the court correctly pointed out, Jack, cannot testify or be forced to testify, which completely hampers other defendants in this case to defend him.
Your Honor, to clarify that the discovery that's outstanding was issued before the indictment was issued, and that Jack Weichman may have employed a common scheme with respect to plaintiff nephrology specialists, and also Dr. A and Dr. B doesn't speak to the substance of the allegations. And the fact is, Jack Weichman has the choice whether or not to testify in this case, but to stay in this case indefinitely.
Well, what about the other defendants? I mean, doesn't it prejudice them, their right to defend? How can they defend without Weichman?
Well, they're separate entities, so...
Yeah, but everything's so commingled and interrelated. How do you defend? I don't know how you can prosecute without Weichman, how you can present your case without him.
Yeah, at this point there's no overlap between the indictment and our case. So we would ask, if it set a trial date, last year they said it was you were looking at the summer of 15, and if allegations come out or a new indictment comes out that does relate to this case, you can address it then. But if we continue to say this indefinitely, then we're just pushing the trial date further and further out.
Where did I stay? Discovery, is that where we stayed?
Stay in the trial date.
Trial date and discovery, Your Honor.
Well, we understood we could still conduct limited discovery. And the trial date that was stated.
The conducting of the discovery, though, I believe Your Honor's ruling was that if we could do that by agreement, the thing could
Right.
But obviously, setting a trial date isn't of any value when discovery regarding Jack Weichman cannot take place.
And Your Honor, once again, on behalf of Dr. Ashcraft, There's all kinds of allegations in this case about this common scheme that Jack Whiteman and Dr. Ashbeck have. Dr. Ashbeck cannot intelligently and efficiently prepare a defense to this case without the testimony of Jack Whiteman. And we're not going to get that.
And, yeah, okay. Well, maybe we can just, where's this federal case at?
It's in the Northeastern County. It's in Hammond.
I know that, but it means it in the initial stages.
Right now, the trial date is April 13th, 2015. We have a motion pending on motions which will not, is likely to be granted for January 15th. So, Your Honor, the trial date is April 13th, 2015. I do not anticipate after that it's likely to go much beyond that.
Unless there's a superseding.
Unless there's a superseding indictment, but depending on the timing of the superseding indictment, as long as the superseding indictment was more than 70 days before the trial date, there may not even be a continuance of that.
Why don't we set it for status early next year, or next year before the trial date?
I'm sorry, before the trial date, Your Honor?
Yeah, let's see, make sure it's going to go that day. If it, you know how these are. Sometimes they go, they don't go.
In February, perhaps, Your Honor?
Yeah, that's what I'm thinking.
We also have a motion for summary judgment pending, if we could schedule a hearing perhaps for the same day.
Why don't we do that? All right.
I would suggest a March date. I think February will be too early to make a determination about the trial date.
Early March?
March is fine.
All right, get in the queue now, Paul.
Could we also have some clarification with regard to the summary? We have some other requests outstanding. So to enable us to move our case forward, it would be beneficial if we could pursue that.
Do we know what, do you know what they have outstanding? That you can give them?
Your Honor, I have a response for request for reduction, second request for reduction I can respond to. I think things like that we can respond to, but short of that, I'm not sure what else you...
Well, we have the non-party. We have some requests that are scheduled to go out on Monday, next Monday, to certain non-parties.
If I understand those non-parties correct, those are directed, though, at phone records of Mr. Whiteman.
Right.
So the text messages, phone records of Mr. Whiteman that I think we have no means of reviewing those for attorney-client privilege, for relevance, for anything of that nature. I think it opens a large Pandora's box at this point. Now, if maybe there's a middle ground where any documents that would be produced go to the court, and the court holds them until we have a trial date set certain, then they're turned over to us to review for privilege and relevance, because there's the records, both text and phone, do impede on potential attorney-client privilege. And the last thing I would want at this point is to have all that turned over to plaintiff while the case is while the case is stayed, without having any chance to look at it, review it, and protect my client's rights as it relates to attorney-client or other privileges.
And we're not seeking privilege information. We've indicated that to counsel. We're willing to narrowly tailor our request to eliminate that concern or address the concern in any way that...
Well, they have to be reviewed. That's the concern. And so then the burden becomes mine to review them for attorney-client privilege while the case is stayed.
These records are directly relevant to our case.
And while the case is stayed, I would ask that that be stayed. And when the case gets going, then we deal with it.
Well, where did you issue these already?
We, consistent with Rule 34, we gave them copies, and they're to go out on Monday, because there's a 15-day waiting period.
Your Honor, there's significant problems with the request. It's extremely broad. It's not only attorney-client privilege, but Mr. Whiteman does deal with doctors. There could be HIPAA issues. There could be communications with family members that are private, completely private in nature. The request, as I understand it, is simply for basically all of Mr. Whiteman's communications, and how that would be narrowed without a third party, or at least someone reviewing them to determine what, in fact, is even relevant, Your Honor. You know, under the Fourth Amendment, this type of seizure would be clearly illegal. because it's an attempt to simply look at the entire life of Mr. Whiteman rather than anything that's narrowly addressed in this case. So, Your Honor, we would heavily, we object strenuously to anything happening with that right now, and would certainly want an opportunity to have the court address the breadth and specificity of what the plaintiff is seeking.
Are you going to object to the subpoena?
We'll file motions to require if it's not stated today.
Well,
One final point. There's two different non-party discovery requests. One relates to telephone providers, and the other request is to DaVita. The same implications or the same concerns are implicated with DaVita. So to the extent Your Honor wishes us to stay the non-party request to the telephone providers, we would ask that we could still pursue the DaVita.
And Judge, we, as it relates to DaVita, I don't believe we have an objection as it relates to DaVita.
If we can, I guess, agree that the others stay, that it might have some.
All right.
Because our idea was to go forward with three.
we'll stay the one, and you can proceed with the DaVita third-party request.
Okay. Then we would just ask after that that all discovery be stayed until we come back before you.
Well, right.
With the exception of what Mr. Tyler indicated would be coming in.
Right.
But we do understand that that request is directed to DaVita, not to Jack Whiteman.
That's correct.
Right.
I'm going off of...
It's a third-party request,
I
right.
think it's business records of DaVita, literally speaking. We're okay.
Okay. Nikki, give me a status date and the hearing on the motion for summary judgment in March.
Your Honor, the first 2 weeks of March, I'm involved in the jury trial down in Clinton.
Okay. Third week of March.
Thursday, March 19.
Very good.
We're good?
Thank you, Your Honor. That looks good for me, Your Honor.
Fine,
Yes.
10 o'clock?
Yes.
Okay. All right.
Thank you, Your Honor.
All right, thank you.